All right. Everybody's on? Great.
Yep.
All right. We are really excited today to bring you our privacy panel. This is our second one, I think, in a month. If you don't know, this is the Masters Conference. My name is Robert Childress. I am the CEO of the Masters Conference. And I just wanted to go over a few details. I want to remind you that we are recording this session, and we will be providing the recording to registration 48 hours after this event. We encourage you to ask questions. We do have someone monitoring the questions, and we will read them off. So please engage our panelists. And of course, they're taking time out of their day to provide you a service and an update on what's going on with privacy. So if we could ask you to stay for the length of the webinar, that would be wonderful. So with that, I'm going to hand it over to Tom Matzen, who is the CEO of Matson Consulting, and I'm going to let him introduce his panel. Tom?
Thanks, Robert. Appreciate the introduction. Those of you who participated about a month ago, we have some of the same familiar faces from the privacy space. As most of you know, if you're on this call, we've had quite I hate using the cliche sea change, but you know, we're lawyers, so I guess that's what we use over the last couple of weeks with the new ruling. Debbie Reynolds is gonna jump off first, but before she does, I'm gonna go around Wayne Matus, Michael Simon, and then Debbie will end with you as an introduction, and you can just transition straight into what did the court say, or who is the court, why do we care, what the ruling says and what it doesn't. So we'll go Wayne, give a minute or two, Michael, and then Debbie will lead right in after your intro. So go ahead, Wayne. This was a brief intro about what you're doing now.
I'm currently the general counsel and co-founder of Safeguard Privacy. We are a SaaS software compliance company, providing you with the ability to assess and maintain your privacy program and practices inside an organization. Previously, I was at UBS doing this sort of thing for 7 years and was previously the co-chairman of the privacy department at Pillsbury Winthrop Shaw Pittman, and I'll leave it at that.
Thank you, Wayne. Michael?
Thank you, Tom, and thank you for inviting me here. I know we're back real soon, but surprise, I mean, this is not so much a sea change as it is a tsunami. And so I'm glad to be back. My name is Michael Simon. I'm with the Xpan Law Group. I'm an attorney. We're a cybersecurity and privacy-focused law firm. We specialize in this area, and for me in particular, I've been working in the e-discovery industry formally for over a decade, actually over 12 years. Although, actually, I started doing e-discovery work back when I was 15. I'm not going to do the math on how many decades ago that was. But I'll say this. I helped write some of the safe harbor certifications for an e-discovery provider. I've been involved with e-discovery companies working in privacy, and this is a tsunami. This is a big change here, and that's why we're back so soon to talk about this. So thank you.
Yeah, go ahead. And just before Debbie, you start, I should have outlined it. We're going to talk about what the Strengths 2 opinion says, what it doesn't say, work on some practical points from our perspective and what to look out for. As Michael alluded to, he's going to touch a little bit on e-discovery and how this directly affects law firms. And then we're going to, take questions as we go. Feel free to type them, and we will, try to filter them and answer as many as possible. So, Debbie, why don't you take the easy approach of what happened here on the 16th?
The easy part. Hi, my name is Debbie Reynolds. I'm the founder, CEO, and Chief Privacy Officer at Debbie Reynolds Consulting. I've been doing privacy sort of in parallel with e-discovery for decades, unfortunately. I dye my hair profusely, so you can't tell. But this is a really this is somewhat mind-blowing in terms of what's happening right now with the Privacy Shield invalidation. So I'll go right into the background of the case and what happened, and feel free to jump in if you feel like, I'm kind of getting off course. This is the Privacy Shield, Safe Harbor, all these things. It's actually one of the more complicated issues in privacy. A lot of times because it has so much history and there's a lot involved. So basically what happened on the 16th of July is that the High Court in Europe heard a case, or it's kind of the ending of this case has been going on for many years, about the standard contract clauses, which are these contract clauses that were created in the EU that if companies are transferring data from the EU to any other country that does not have adequate does not have adequate protection, these are clauses that companies have been using for many, many years. What happened, which people didn't anticipate, is that in this ruling, they also, in addition to saying that just copying and pasting a standard contract clause is not all that you should be doing for these transatlantic transfers, they also invalidated the Privacy Shield. So that's the part that people really didn't understand. So the Privacy Shield, and you kind of have to talk about the Safe Harbor too. So for the last 20 years, the US and the EU have been trying to find an acceptable mechanism for businesses to transmit data from the EU to the US and try to separate it in some way from the laws in the US and the EU. So for the last 20 years, the US has been on this path towards more surveillance and less individual privacy. And the EU has been on the opposite path, where it's more, less surveillance, more rights of the individual, culminating with the GDPR. One thing I will say is that as we get in this conversation, we were talking about this, standard contract clauses, binding corporate rules, the Privacy Shield, and Safe Harbor all predated the GDPR. So this, to me, was a tune-up on everything. So that's one reason why Privacy Shield, I feel like, got tossed out, because it didn't really connect with sort of where the Europe is now and where they want to be in the future. So that's kind of my background of what's happening with that.
Thank you, Debbie. Wayne or Michael, do you want to chime in on, we've had some questions from clients. So one of my roles, somebody just texted me, I didn't tell anybody what I did. So sorry about that. Nobody really cares.
I care. We care. Come on, we care.
I'm a DPO for for 3 companies. So I serve that role in addition to doing some general consulting and other privacy realms. So sorry about that. But we get questions about, so is Privacy Shield dead? Will data stop moving? Should we keep paying the Department of Commerce our fees? Should we ask for our money back? Or the Department of Commerce has made some statements, but do either of you want to take that as far as what does that mean practically to somebody holding a Privacy Shield certification and that alone at this point?
Sure, but I'd love to take it because I know Wayne has a slightly different view, and good controversy makes for good TV, as they say. So number one, I was not aware that any U.S. agency would give you a refund. So if they do, more power to you if you can get money back. Let's be clear. The EDPB, the Data Protection Board, the old Article 29 working group that transmogrified as a result of the GDPR into a group with some actual power, I believe, issued a FAQ a couple of days ago on, is the Privacy Shield dead? Here we go. I will say this. I'll read it right from it. Number 3, is there any grace period during which I can keep transferring data to the U.S. without assessing my legal basis for the transfer? Wow, way to read that. No. The court has invalidated the Privacy Shield decision without maintaining its effects. It's done. It's gone. Okay? And at the same time, as Tom alluded to, or maybe elided to, or maybe both, the Department of Commerce is taking a strange take as to this? On July 16, 2020, on their updates to privacyshield.gov, they say the Court of Justice of the European Union issued a judgment declaring as invalid. Strange scare quotes, those are theirs, blah, blah, blah. This decision does not relieve participants in the EU-US Privacy Shield of their obligations. The Department of Commerce will continue to administer the program, including processing submissions for self-certification and recertification. Wow. You know, I don't think we get to decide whether it's valid or not. I don't think if you've got an application you're planning on doing or a certification, now would be the time to spend your probably limited resources in these difficult times, as we keep hearing, on something like this. And while I recognize there may be some reasons, for example, that we still have, at least for now, a valid, very similar construct with Switzerland, which is separate, that I can imagine that maybe in some world the FTC might see this, take this badly. I know there is a withdrawal period from this that's mandated, but there's, what are you withdrawing from? It's dead, it's gone. And so,
Yeah,
you know,
it's dead.
maybe
It's
we're
dead,
waiting till
dead.
I got it wrong.
All right, so Michael,
Wayne, you're
Michael stepped on one or two talking points, but
Sorry.
that's
Sorry,
quite-
Crockett.
because you and I talked about this.
Yes.
So first things first, if you're dealing with Switzerland, you still want it. Okay, we agree on that. All right. What you didn't say is there is an issue between the UK at the moment, which is withdrawing from the EU, and the EU, because they signed an agreement with the United States to share surveillance data. And it may well be that the UK's Information Office takes a very different view of the Privacy Shield after the EU determines that the UK is inadequate, if that's where it's going, which it is looking like it's going. So that's another reason why you might want to keep it. Yeah, there is a 90-day withdrawal requirement, but that's not from the FTC, but that's not the reason I would keep it for the FTC. It is a defense to an enforcement action from the Federal Trade Commission, and you may want to have a defense to an FTC enforcement action. In other words, what I agree with is that this is very much like an expired passport. It doesn't have no value. It doesn't have as much value as a real passport. It doesn't even have a tenth of that value, but it has some value. And if you already paid for it, you may as well keep it. Now, in terms of renewing it, more difficult decision.
No, so here's a question I'll throw to you then. Okay, so a client calls me, perhaps looking for advice on and selection for e-discovery providers, and they want to know who's ready to handle this big change. And they go to a site of A, B, and C providers, and it says we're Privacy Shield certified on, you know, let's say 2 of them, and nothing else. I don't know about you, but that doesn't give me a lot of confidence that
Look, let's go into the heart of the decision for a minute and then get back to your point, because
Okay.
I do think that there's nuance here. The Schrems 2 decision essentially was on 2 bases. One was that there was a lack of adequate redress provided under the Privacy Shield system. And that means, as far as the EU is concerned, that you provide the ability for someone who's protected by EU law with the same ability to defend their rights as they would have if they were sitting in Europe.
Yeah.
You don't have to give them access to a European court, but it has to be equivalent rights. That was number one. Number two, US government surveillance. So let's say you have an e-discovery provider, they're Privacy Shield certified, and they enter into a narrow agreement with you in the nature of a binding corporate rule,
okay.
which says, number one, they will not accept data that is of interest to the US government, and you will not give it to them. And 2, they'll provide a certain level of minimum security. And in addition, they will agree to arbitration under the international arbitration rules in New York or London. Do you maybe, when you perhaps file those with the DPA in Ireland or something like that, buy yourself some time and get yourself the ability to keep your privacy shield with a patch? And is it possible that the US ultimately, once this administration has either changed or is reorganized, or, you know, we're talking about past the election, if somebody goes back to the EU and says, you know what, you wanted these two things, how about we give you this? I'm not saying that the privacy shield can't come back to life. It won't come back to life like it is now, but I'm not so quick to bury it.
Okay.
I'm going to throw a question we got. Just, Wayne, I think you hit on this question being, so you certify under Privacy Shield and you withdraw, are you leaving yourself open to an FTC action for a misleading trade practice?
Well, not if you communicate honestly and fairly that you're withdrawing. And, you know, the basis of a Section 5 violation is a deceptive practice. So if you fully disclose, I think you're fine. Now, do you have a problem with regard to some people who signed on to a contract with you expecting that, and now you're saying you're not delivering it? You may have a breach of contract claim.
Yeah.
I just don't think you have an FTC claim.
Yeah, it's gonna be hard.
Debbie, what are your thoughts on Wayne's take that it's not, it could come back? Well, let me rephrase that. Safe Harbor got a reprieve with Privacy Shield. Should anybody listening to this think that, oh, don't worry, the U.S. government has another one up its sleeve, that it'll just grandfather you in, hang tight, we'll get over this? Or do you think the EU is finally going to force change? Do you see another savior coming?
I don't see another savior coming. I think they're done, like dead. I really do, because really this is really diplomacy that's sort of broken down and sort of broken out into like an open cage fight. Literally, this should be sort of behind the door negotiation type of stuff. So it just shows how much the relationship, between the U.S. and the EU has degraded up to this point. Because literally, they've been trying for 20 years to try to find ways to bridge this gap. So the fact that they've sort of kind of cut this off at the knees tells me that there's a lot of woundedness on both sides, I think, of the issue. And, now there's kind of some, I don't know. Now, because there's a PR issue as well, I think it's going to be some other bravado that follows this on a political level. So I don't know if you all remember, or you probably do remember, because I've been watching this play out, for 20 years. But I always wonder why they even enacted the Privacy Shield, because they had always said they had a problem with surveillance. This FISA issue that they had mentioned in the invalidation, that's existed since, 2008. So these problems were there already. So I don't think they really, except for talking about an issue about redress with the ombudsman, and that it doesn't really rise to the level of having a person be able to get redress if the government has their information for surveillance. That was like the only new thing that I had heard. So all these objections to doing this transfer existed or predated the Privacy Shield. But if you remember, this was during the time of the election, and the presidency was changing, and I think they sort of wanted to see how things would play out, and they just haven't played out very well over the last few years.
Debbie, I think that the answer to your question is the GDPR is 2 years old, and Privacy Shield is older. And Privacy Shield was a politically expedient agreement between governments before we had the creation of data protection authorities and a court system that could review complaints that were filed with the data protection authorities. And when you take this outside of the government politics arena and move it into the enforcement of the law as it's written back in 1995 with European fundamental rights, you got a very different audience. I'm not convinced that the German government wanted this result. You know, I don't think they did. I don't think the UK wanted this result. The UK doesn't want the result that it's getting out of the EU courts as it stands right now. So what you're seeing is that difference. And when you analyze this in terms of a business and what you're supposed to do next, you have to be very cognizant of the fact that what might be a political solution may not happen because there's a data protection authority that has a law with a court behind it that views things differently. And that dynamic is not unimportant.
One other comment, just last night, I got a pop-up ad from Siemens saying why you should trust Siemens Americans with your infrastructure data. They're putting it was like a pop-up ad, which I found somewhat grand, that German companies trying to politicize. Hey, Americans, you can trust us with your infrastructure. Just an anecdote. It seems a little.
You know, look. I think you make an important point, and I think that you need to start to think about this a little bit. What really has the Europeans upset? The financial transaction data of Europeans that are in the financial system, they don't want that stored in the United States and subject to government surveillance. They got ticked off when the United States went into London and saw the SWIFT transactions. They don't want you to tap into Merkel's telephone in Berlin. They want the telephone data to be staying there. They've seen the abuses that they believe have occurred with the US government doing surveillance in Europe without, in their view, their permission. And frankly, they didn't have their permission. Whether it was justified or not, different issue altogether. But you know, they didn't have their permission, and they see that as an abuse. So there are types of data that they are going to be very tough about. And then there's commercial transactions when you're buying a vacuum cleaner, you know, from Dyson's in the United States. Maybe they don't care about that much.
Yeah, we're going to transition slightly. I'm seeing some questions. So I'm going to mold these into kind of one. We're going to move on to, okay, Privacy Shield gone, just slap on 6-page SCCs and there we go, right? They didn't say I mean, even the headline of the press release of the result was, you know, SCCs declared valid, but then you had to read about it and you're like, well, wait a minute, maybe not. And to that effect, you know, yeah, we're aware Berlin saying immediately everything must cease, you know, it's in effect now. The UK said hang ICO's guidelines or guidance from last week is hang tight. You know, the official EDPB saying kind of hang tight. We're going to give some more safeguards around SECs. So what do we do with the SECs? The standard contractual clauses, some people call them model clauses that were written before the GDPR. Is that where we run to? Maybe we can go with Michael, and we can go around the form and kind of determine, you know, we can get into some of the practical tech possible answers. You know, we had a pretty spirited discussion yesterday preparing for this, but let's get into, you know, what does somebody do now so they don't lose business from a client overseas? And what does somebody do if their vendors now have said, hey, we're Privacy Shield dependent. Now, is it another round of addendums to data protection language contracts, or take any and all of those, Michael, and solve it?
Sure, yeah, I can. That's definitely a compound question. But the good news is I get to use scare quotes again, because are the SCCs valid? They're valid. There's a lot of criticisms of them in the decision. There's many folks who have commented after this that, you know, don't go putting a lot of bets on whether these will survive. As well, you touched upon another really critical thing. We have 3 sets of model clauses. We have 2 that are controller to controller and 1 that is controller to processor. They are all pre-GDPR. The controller to processor, let's keep in mind here, the old directive of pre-GDPR, if you were a processor, the level of responsibility and trouble you could get into was pretty low. You know, that was an easy way out for an e-discovery company. I'll admit, we did that too at the company I helped. You know, it was, hey, you know, we're a processor, no big deal, whatever. The GDPR has very serious rules and very serious requirements in Article 28.3 and which brings in another half dozen articles with their own sets of requirements as to what a processor needs to do. Those clauses don't cover that. They don't cover the processor back to the controller, the processor to a subprocessor. So if you're using relativity and you have to send it to pick a company brain, goes to brain space, or when it goes to the other side, they're looking at it. And under Article 42, that's a processing. You've got a whole bunch of things that leaves out. So, you know, to answer some of the questions I've seen come in, I don't think you can just slap on a bunch of model clauses and say, we're great here and we feel like we can hope no one comes after us. I think you've got to look, you've got to craft something that's overall a data processing agreement that makes the correct promises and keeps them under Article 28.3. But you've also got to cover an individualized assessment of what the data you're getting. Wayne touched upon that. If you're a provider and you're taking data from the EU that you think has a real high likelihood that the US government's going to be interested in that, you're taking a ticking time bomb. If you're taking about, I guess Wayne buys his vacuums right from London, I don't know. Normally I go, I guess I don't know. But if you do, and that's all you got, some emails and, you know, a receipt for a Dyson, that's probably highly innocuous. But you've got to look at each time to be able to comply with this decision and to keep yourself potentially out of trouble. You've got to look at data volumes, data sensitivity, the number of potential custodians. I had these written down here. Yeah, one more. Can't find it. Here we go. And then, of course, the U.S. interest in it. The chance that this is going to be something that the government's going to want to get their hands on. And again, if it's super innocuous, easy. If it's super dangerous, easy, leave it alone. In between, I think you got to make some assessments. And most importantly, you know, one of the rules I've always been taught about, you know, defensibility is if it isn't written down, it didn't happen. So look at it, make your assessments under your policies and under the contracts, and then document it, because you may have to explain it later.
I was on a call with Bruno Gencarelli the day that this decision came out, and Helen Dixon. Zoom, to be technical, but they're like calls these days. And he made it extremely clear that each transfer needs to be separately documented. A balancing test needs to be made with each transfer. And so when you're talking about the e-discovery context, it's identical to, frankly, any other context, whether you're dealing with employee data, consumer data, aggregated data, whatever it is, what is the likelihood of surveillance? What is the history of surveillance of the company which is importing the data into the country that does not have an adequacy decision? And, you know, and what is the redress mechanism? And, you know, one thing we haven't talked about, and I haven't seen anyone else, frankly, talk about it, but has come to my mind, is the critical importance of a protective order in the context of litigation. And I actually think that one neat little trick that I'm giving away for free here is I would put a provision in that says that if the government comes knocking on the door with a 702 or FISA warrant and says to you, you may not tell the party whose data we're looking at that we're looking at their data, which is what the government warrants look like, that you have a protective order that says, and I am ordered to tell the judge. And then you have to go tell the judge. And the FISA warrant isn't going to be able to stop you. And if it's going to stop you, it'll stop you in the nature of you going to the FISA court. But one way or the other, you're forcing it upon a judicial authority to hear something, which is getting closer to exactly what the Europeans want, which is some form of judicial review. And if a FISA court rubber stamps it, that still might be good enough.
No, thank you, Wayne. Debbie,
If rubber stamps it, it still might be good enough.
Yeah, Debbie, do you want to add to this? Trying to read back to SCCs, what other safeguards? That's a great tip from Wayne. What other, and I think between the conversation he heard and the interview he heard, we're trying to, everything here is what are these additional safeguards the SEC is going to be, to me. It's like, what can we do what's the test? What's the analysis? It sounds like we have to do a lot of tests. It sounds like we have to include a lot of factors, but do you have anything to add, Debbie, to what we could be coming down? And some questions have popped up before you go, Debbie, to Wayne's point about Dyson, about how that's really a contract. I know you were being a little bit.
I was being glib, but if I want to, if I want to make that a practical example, it's Macy's and they're regularly fulfilling contract shipping goods. I don't think that this is going to upset the DPA.
Yeah, you saw the derogations of if you're dealing directly with an end user kind of coming back, but
you have essentially, I think you have consent.
Absolutely. Consent still is very much in play. So obviously consent is like the last, resort. So you want to try to.
But I hear people some people think consent's the be all end all, but it can be revoked. Can you maybe just explain that to why consent isn't maybe always what it's cracked up to be, and why it's like a practical point?
Well, consent, first of all, consent of the individual, it's a lot more work than just having kind of this blanket rubber stamp ability to be able to transfer data, whenever you want, which obviously doesn't exist anymore. But consent is also very fragile and is granular. So people can decide what they want to consent to or not. They can revoke consent at any time. It's just harder to do it that way. I think companies, depending on the types of services they have, I have seen people try to use consent. Let's say you use some web service and you have some account and they're like, well, we do our processing in the US, in order for you, we want your consent to actually do this. And people will say, this is a service that I like and I'm going to actually do this. I don't think an authority is going to come in necessarily and sort of stop that. But any company needs to be or should have already been able to do this based on the GDPR, be able to, if they had to have consent from the individual, have to have a mechanism for them to be able to have some visibility into what data that you have about them. And then also that they be able to revoke consent and you be able to either delete or send their data back.
Yeah, there's a lot of tricky things about consent, and Deb, I think you covered a lot of really good ones. One of the issues about consent is, in the fragility, is there are precedents in certain EU member states, particularly Germany, that have said that because of the nature of the employer-employee relationship, employees can't really be deemed to have consented freely and fairly to anything. And so these are going to be a lot of custodians who are employees. You're going to have a problem with that. As well, let's keep in mind two things. One, if someone has consented and they're your employee and you are somewhere where you can get that, congrats. Now they have kind of the ultimate protection against being fired. Because if you fire them, what are they going to do? Are they going to withdraw consent? Yeah. The second thing is, I think we need to take this as a whole and ask ourselves, is someone who has data that they think might be likely to have the US government come and want to get it? Are they worried about that stuff? Is someone like that going to want to consent? And if we're looking at the more problematic situations, I get it. Consent can fix a lot of things, but there's going to be a natural issue there. Who's going to want to consent to something they think the feds are going to take?
Yeah, and Wayne, I took us off the road a little. I'm going to bring us back. But I think that's important because sometimes I've been in conversations where you just get consent, and it's more complicated than that. But Schrems 2 doesn't say anything about, hey, throwing out consent. It really, it addresses other issues. But, I want to throw it to Wayne about, do you see, back to how do we solve this? Is more data localization to Europe, do you see as a trend? Do you see that as a solving the problem or just a good idea when it's buttressed by additional SEC analysis and additional safeguards? Could that be one of those additional safeguards we might see come out?
All right, I'm going to riff for a couple of minutes. All right.
Well, that's some jazz.
Since you asked me a sufficient number of questions, that it's basically, so Wayne, what do you think? I think businesses that relied upon the privacy shield need to be concerned and they need to replace it. Okay, that's number one. I think that they have to start thinking about, in the first instance, are they a controller or are they a processor? Are they an exporter? Are they an importer? What type of data am I dealing with? And I don't mean like something the government wants to look at. That's one criteria. I agree with that. But is it employee data? Is it consumer data? Is it medical data? And under what bases have I brought this stuff in? Then I think they need to look at what the available mechanisms are and how they might use them to address the issues of government surveillance and redress. And by redress, I mean an adequate means of redressing something that was done wrong. Standard contractual clauses, I think, are a very likely and the most logical alternative. I think that qualified, creative lawyers can come up with some standard contractual clauses that add the Article 28.3 stuff to it and go submit them. Submit them to a DPA and see if you can get them approved. It's going to buy you some time. That's one thing I think they can do. I think that binding corporate rules are pretty safe and that companies who have them right now don't have a lot to worry about because you've already had a data protection authority approve them. You now have a court that said to the DPAs you didn't do enough. So you probably need to go back and take a look at what you've done and maybe resubmit them. But I wouldn't worry about stuff because once you resubmit them, it's going to be years before you're going to get a response out of a DPA, considering the number of these things that are going to get resubmitted. And I think that for the e-discovery industry, the use of protective orders that attempts to address government surveillance, trying to keep in Europe the materials that are the most sensitive on the government surveillance side, use of anonymization, use of encryption. I think you have to get creative. I think you have to document. I think you have to act in good faith. But if you do that, I think there are ways of dealing with it. And I think that people need to understand that there's a hierarchy under the GDPR in terms of transfers. Article 45, adequacy decision, is the highest standard. US doesn't meet it. Appropriate safeguards under 48, like standard contractual clauses, that's good. Binding corporate rules are in Article 47, but they happen to be referred to in Article 46. They're in Article 46, they're approved alternative. And then you're dealing with the derogations, which can be consent, can be for the fulfillment of a contract, or if you don't do a lot of transfers, if you're doing a limited amount of data for the legitimate interest of the controller that is not stepping on the rights of an individual in any egregious way, notify a DPA that you're making the transfer because that's required under Article 49, but then go do it.
Right.
So I think that it's going to require a lot of work. It's the Privacy Lawyer Employment Act of 2020, because every single one of these is going to require an analysis. You know, what's my mechanism? What's my justification? Put it in the file. But I do think that this is not the end of the world. Makes the world more complicated.
Well, it's not, and I think you know, when I talked about, I've successfully used derogations over the years for this. I think it just means we have to get more in the weeds with all these transfers and be able to know exactly what type of data that we're transferring, figuring out not only the legal mechanisms, but technologically how we're going to do this. Are we going to anonymize stuff? Are we going to create pseudonyms for people? Are we going to do encryption in some different way? Keeping it in country, obviously, you know, that's a easier, well, not a easier one, but that's obviously what these types of rulings want. to happen, being able to transfer the data to a country that has adequate protection currently. Brexit is still up in the air. I guess they're trying to see what side they're going to go on. Are they going to join more? Are they going to swerve more right or left toward more U.S.? How we do things as opposed to the way EU does things. I think it's a pivotal moment for the United Kingdom right now. Because they could really take this to their advantage, in my opinion, with Brexit going on. So, I mean, there is not one issue. I think, any transfer that you're doing, you need to get really down in the weeds about what type of data you're transferring, who is it going to? Do you even need it? This is the top conversation to have with people. Like, do you need this stuff? We can't, the way, especially Mike was talking about with e-discovery, in the U.S., we just vacuum data. We just vacuum it up and just, throw it in the hopper. Yeah, throw it in the Dyson or whatever. And they just can't, you can't do that now. You really couldn't do that for years. So I think from my perspective, companies, well, just back up. So at the height of the safe harbor agreement, there are over almost 11,000 companies that were signed up. So then once that was invalidated, less than half of those people went to Privacy Shield. So, at least half of that group sort of got the message, and they're doing what we're talking about now, which is finding alternative methods to do this transfer.
And I think those are all great points, but I'm gonna, I'll say this, it segues into something I've been pushing, which is, for the last few years, there've been a few jerks running around the e-discovery industry and conferences saying, hey, Privacy Shield does not apply to what we're doing. It does not work for, in terms of the requirements of consent, the principle for notice, and the principle for onward transfer. And I've been proudly one of those jerks. It never really applied to us. And we were able to kind of just get away with it. That's come to an end. Those days are over, and Wayne and Debbie, you're both right. This is going to be more complicated. It can be done, yeah, but the easy days are over.
Well, it's particularly difficult for the law firm that has a litigator sitting somewhere in the United States wanting to look at data and thinking that all I have to do is host it in Berlin and I'm cool. No.
Yeah, that's not what that word means.
I want to get to another question here. It kind of goes with, I think Sedona released a kind of how to avoid jurisdiction of the GDPR and avoid the fine paper. I think it came out a few weeks ago.
They have a webinar tomorrow.
Yeah. And the question being, if you're submitting SECs, which, you are, as written, submitting yourself to jurisdiction in the EU, does that then eliminate your defense if it came to that, if you got fined with it?
I don't know that you have to submit to European jurisdiction. I don't know I don't know if that is a requirement, because the requirement, as I read it, is that you provide, and this is certainly what Shrem says, you have to provide an equivalent mechanism for redress. So that doesn't...
Which could be, we talked about some of those other options the other day. Do you want to, whether it's figuring out international arbitration, or are you looking, what could some of those others be?
I mean, ultimately, you're going to need to get them approved, and I don't know if you're going to find a DPA that's going to want less than enforceable in Germany, or I can enforce the GDPR in the state in which you do business, Delaware, New York, whatever. But it doesn't necessarily follow that you have to submit to EU personal jurisdiction.
All right, thanks for that question. Sorry, anybody else? We got about 15 minutes. Let's keep firing the questions, but we'll keep moving around. Wayne, you hit on a topic of the lawyer sitting in Boston looking at data in Germany. How do they're technical, we all know that we're flooded with technical tools about encryption, and our encryption is really good. To address the surveillance issue, if you do real-time and at rest encryption, or how reasonable do you think, or to Michael or to Debbie, we need to be? Are we worried about deep packet inspection under the oceans? Or are we worried about FISA warrants? We see surveillance thrown out a lot as something to be on the lookout for, and that kind of strays a little bit out of the privacy lane. But just to understand the government, that's exactly what Trump himself kind of was worried about post Snowden and Facebook, and it's exactly what they seem to continually be worried about in this latest opinion. But I want to make sure we as a U.S. privacy practitioners just don't, surveillance, and we never define it, kind of like.
I'm going to let others answer the question, but before they do, I'm going to say that the analysis needs to be made separately for the exporter and the importer.
I think that's a very good point.
We start seeing exporter and importer use a lot more than processor and controller. Sometimes they're one and the same, and sometimes they're different. But
or sometimes they're both. Yeah.
Yeah.
Sometimes you can be a controller and a processor, or a dual
But understand that the transfer out of the EU, even if it's controller to controller, that export is what picks up Article 4.2.
Yeah.
That is itself processing. You know, when we're talking about regulators, we're talking about reasonableness, we're talking about documentation, we're talking about being able to show that you did something that at the time was reasonable and that you documented it. I guess, you know, maybe one of the things I always advise people when you're talking about dealing with regulators, it's like that old joke about, you know, two hunters that come upon a bear in the woods, and they start running, and one hunter turns to the other one and says, "This is crazy, we'll never outrun the bear." And the other hunter says, "No, I just have to outrun you." You know, regulators have limited resources. Regulators pick their targets, and, you know, the key is don't be a target. Do things that, you know, when the regulator shows up, that you can present to them quickly to show that you acted the right way, and they will go away instead of digging into things and seeing that there's a problem that they can now potentially take advantage of. Don't put yourself in a situation where you're going to have very public problems. And if you have data that is so sensitive that you're worried about someone sending a submarine to tap a cable, yeah, I think you need to take a step or two back and assess what the heck are you even talking about with bringing that data over. You know?
I will also add a fly in the ointment with the Cloud Act. So this makes it just way harder. So basically, the Cloud Act says that a U.S. company could be compelled to turn over data to the U.S. government, even if the data is overseas. I think initially people are thinking, well, if I have a subsidiary in a different country, then it doesn't matter. But that is totally out. The one thing that companies have really fought for in the Cloud Act is still there, but that may be eroded by future legislation in the U.S., is that they aren't forced to decrypt stuff. So let's say you receive something that was encrypted, you're not under any obligation to decrypt that information. So encryption comes into play here in some ways. Obviously, you know, anonymization and being able to use pseudonyms definitely helps. Doesn't get you all the way there, but that is something that I think is still kind of a battlefield that's being fought about encryption.
Yeah, and we had a question pending. I said we would get to it, so I want to give us enough time. And you know, it be interested in your thoughts, and it'd be somewhat philosophical. But why hasn't the U.S. changed? Why isn't the U.S. going to, you know, do what they are in the name of business? Of, I guess change meaning stop their surveillance. And I'll throw in a little history background from my perspective. You know, it came up on the call yesterday. The one far extreme is, why is this guy named Max Schrems, I think lives in Liechtenstein, determining U.S. foreign policy and how it enforces terrorism? And you know, we have one guy that's the one extreme. Some cynics would say that we shouldn't allow one guy to determine our policy, but historically, I mean, any internet connection we're in through the U.S., even if it was France, you could be in a French coffee shop texting your buddy, and it would be routed through one of the switches in the U.S. for a while. I mean, it's one of the cradles of the surveillance system we have. And again, I'm not agreeing with it. I'm just trying to say, you know, for the U.S. to change and to meet the standards of the EU, I mean, we get back to the fundamental change of what's a fundamental human right and what's a property right and what's a commodity. I don't see the U.S. government changing how it operates with the Cloud Act and with other surveillance techniques. Do I think, and I'd just be curious, the other three of you, your thoughts on, you know, we even got into yesterday the Hague Convention. Does this invalidate the Hague Convention? Like, how will this affect, will the U.S. change in light of this? Will it get enough pressure? I think the big four are testifying today in Congress. I'm curious if this comes up at all. Maybe probably not. But if anybody's watching, let us know. And do we think the U.S. government will curtail and make changes to, in effect, increase business flows? You can go, Michael.
Well, let's say this. You know, there is actually the fact that you bring up the testimony today. Facebook is there, right? And, you know, what did this all start with? This is Schrems about Facebook. There's a connection there. And, you know, we've had folks ask, you know, what do you know, take us back and talk about Facebook and Cambridge Analytica and the problems that happened. And God, there's no time. I think we're doing more of these. We can maybe get into it then. My apologies. But, you know, the days where we would announce at the diplomatic level, you know, that gentlemen don't read other people's mail. What was that? That was World War I, right? Before that, that's long gone. We're not going to change that way. We're going to continue to monitor, and other governments are going to monitor. And as well, there's a second fact that, you know, in the EU and in other countries and other areas of the world, they see these things. They see what Max Schrems is bringing as him asserting his fundamental rights. They see this as one of their fundamental rights. We have our own set of fundamental rights in America, and there's not too many people, I think, who include privacy in it. I would disagree with that, but that just seems to be the way. We tend to take more of a property approach to things. This is mine. I get it. Someone should pay me for it. I should be able to give it away if I want or sell it. And then finally, in terms of, and I get the question, you know, who is this young Austrian student to change the world? But at the same time, you know, how many years was it ago that a young man led a march across the Edward Pettus Bridge in Alabama and forced us all to confront the inherent violence that was keeping the American system then going, knowing that the police were going to beat him or kill him and the people around him? And he was, you know, Congressman John Lewis laid to rest this week in Congress. It takes someone to change the world. And if it happens to be Max Schrems, then so be it. You know, there are those who change the world in a good way. And, you know, if we are going to get to a point where we can all see privacy as something fundamentally important to us, particularly here in America, I think that's a good thing.
I think privacy would have to raise to a fundamental human right in the U.S. for some of these things to curtail in some way. Obviously wouldn't stop them because the U.S. has had a very different trajectory than Europe. So I think September 11 has changed, you know, a lot of what we thought about surveillance and people's rights. People were saying, you know, doing the trade-off between, you know, security and privacy, which is, you know, as I feel, that's kind of a false trade-off, but it definitely happens, and being able to gather all this information, you know, can lead and has led to abuses that we had not intended. But also, I think, you know, the third party doctrine is a problem, where your data rights and the rights of things that are the protection of information that's in your immediate vicinity as opposed to something that's held by a third party has different levels of protection. Again, privacy has a fundamental human right. So to me, in the privacy layer cake in the US, it's like the Fourth Amendment, right, and the Constitution against unreasonable search and seizure. Then it's the Patriot Act, and then everything else after that. So until privacy can jump beyond the Patriot Act, I don't think we're going to be able to change at all in terms of what other countries are looking at for privacy as a fundamental human right, because there's so many things that are taken away because of that that you really can't add in later. So a consumer law is not going to add in, not going to take away from surveillance right, because it has, it's a higher issue.
Right.
Patriot Act's a tough layer to get past. You're right, Debbie. It's like going, hey, great chocolate cake, layer of chocolate mousse, then a flour chocolate, then scorpions, live scorpions. I mean, just, you're right.
Okay, Wayne, I'm going to turn to you. Wayne, I want to get your comments, but I just want to give one piece of hope. Schrems did release, a press statement about, is he going to go after the UK post-Brexit? He said he has no interest in dealing with Britain once they're gone. So him and his none of your business crew apparently is drawing a line there. So maybe there's some hope. But Wayne, your thoughts on likelihood of U.S. making a policy change or adjustment to help to get out of this, I won't even call it a mess. It's just different languages talking to each other.
Look, I'm going to give personal opinion here. I think the U.S. lost its way after Mark Zuckerberg was 2 years old. Because back in 1986, we passed the Steward Communications Act. And in those days, internet service providers were thought of as the rulers of the internet, not the Googles, Facebooks, and Apples, and the like. And legislation has not caught up. What was the Steward Communications Act? It was an attempt to protect communications from unreasonable searches and seizures, just the way that we always expected our personal lives to be protected. And the US has, quite frankly, in my opinion, lost its way. Now, having said that, do I think that the Europeans are doing the same thing to American data if it's sitting in Barclays Bank? Yeah, I do. I don't think that we're behaving, intelligence services do what intelligence services do. They look at data and they try to enforce the law. I was a government investigator once for a federal agency. I know the data that I looked at, and I don't fault them for that either. It rests with Congress. And Congress can address this or not.
We've actually got an open question about how the CCPA and CPRA, which I think we're all just assuming that is going to pass.
Yeah.
I mean, maybe it's not just Congress. Maybe we can.
It does. Look, the CCPA, the CRPA, do not address the fundamental issue of government surveillance and do not address the issue of redress for the violation of GDPR rights.
Absolutely. And also CCPA doesn't cover every consumer or every human, right?
Sure.
So the GDPR is about human rights, not consumer rights.
But is it at least a step in the right direction?
Absolutely correct. So apples and oranges.
We're at a minute left. Our plan to the folks on this is to do this again next month to see where the guidelines are coming. I wouldn't call them guidelines. The guidance is coming quick. They say we get a lot of hold tight, and when something new is worth sharing, we'll probably put something together and come about with it. And Robert, go ahead. I see you want to. Yep, sorry, Robert Childress, everyone.
Hey, all right, that was fantastic. I can tell you, each one of you have a quality, and if you add it all up together, you would be like the Pacific Rim robot of privacy. Because all of you together form one fantastic group. And I really appreciate you guys taking time. I want to appreciate everybody for staying on the webinar. They stayed. Yes, we are going to do another one, right? And maybe in what, 2 weeks?
Well, yeah, 2 to 4 weeks, depending on.
Okay.
We want to have enough today, but we could probably do this every week and make it.
There's a lot going on. There's going to be something happening in the next week or two. You know it.
That's true.
Well, I tell you what, I mean, I'm available anytime, so you just tell me what you want to do and we'll do it. Just like we did with this. And so if you want to have a standing kind of webinar that people know and is aware of that it happens every X time, we can do that. So that way they know, okay, I'm going to be there on Thursday, you know.
I'm open to that. I mean, this is not getting any less interesting. So,
Oh,
So,
I love it.
so much stuff
much
happening.
more. I agree.
all right, so let's think about it. I know everybody's listening, but let's think about it like Privacy Day and choose a day or twice a month or whatever.
It can't be Wednesday because Wednesday is Prince Spaghetti Day. But beyond that, we can do pretty much anything.
Absolutely.
There's
I
so
want
many.
this. I want the scorpion cake that Michael did. So I'm interested in.
So
Thanks for
Chocolate scorpion cake. I'll see if I got the recipe from America's Test Kitchen.
I would get it from Clash of Wrath of Titans or Clash of Titans. You know,
Yeah.
they got a lot of weird food. All right, guys. Well, thank you so much, Tom.
You're welcome.
Thank you, Tom. You did great. Thank you. Thank you, everybody, for
Thanks,
attending.
everyone.
Robert,
Stay tuned.
thank you, Debbie and Michael.
All right, guys. Cheers, and thank you everybody for attending our webinar. Have a great day.